as Matt said, I'm one of the attorneys here. I have focused primarily in our long-term care planning department. I work a lot with Tammy Zilski, who's going to be talking here in a minute. And I also work a lot in our estate administration department. So it kind of helps give me kind of a unique perspective, because I'm able to see how the planning we're going to talk about today not only helps protect, during life, but it also helps protect an easy administration process for your beneficiaries if something were to happen to you whenever you pass away. So I'm going to go to a slide here. I do have, if I can get it to go here. All right, so I do have a book available. We're not going to get a lot into Medicaid planning and the strategies for nursing home care, but if that's something that's of interest to you, I do have a book available that goes over a lot of the Medicaid planning strategies that are out there to pay for not only in-home care, but nursing home care. So if that's something you'd be interested in, feel free to email Kyle or send him a message whenever the seminar is done, and he can make sure that you can get a copy of that book. All right, Tammy, I'm going to hand it over to you.
Okay, great. Welcome, everybody. I'm Tammy Zilski. I'm a long-term care planner at Steinbacher Goodall and Yurchak. My background is in social work. I have a bachelor's of social work from Eastern University. And prior to my employment here at the law firm, I worked as a case manager at an area agency on aging, which was really a great opportunity for me to learn about community resources and work with the state programs. And then I'm also, I have a background in hospice social work. So I've worked with people, at the end stages of their life. But I've been with the law firm for a little over 13 years now. And like Brittany said, we work together to help people develop estate planning and long-term care planning in advance of a crisis. But then we also are able to step in if somebody finds themselves in a long-term care crisis where they need help now. We can help them with benefits planning, community resource education. And the other thing that we have recently gotten our staff certified in as a dementia practitioner, and that really just allows us to help our clients make sure that they are getting all the services they need if they do have a diagnosis of dementia, from the legal planning all the way through the benefits planning. Okay. So the first thing that we talk about when we meet with clients is, why are you here? So it's important for us to be able to understand what your goals are so that we can help you develop a plan that meets those goals. So some of the reasons that people come to the law firm is they want to plan for themselves, or they want to plan for their spouse, their children, or disabled children, grandchildren, make sure that education trusts are set up. Sometimes brothers or sisters or other individuals they know, and sometimes for parents. So when we're looking at why somebody is coming to the law firm, we also will talk with them about their desire to protect assets. So, as we all know, long-term care services are very expensive, a little over $10,700 per month. And so it can quickly deplete your estate if you find yourself in a situation where you need care. So the legal planning that we're going to talk about today can really make sure that your hard-earned assets are protected. If you have a family business, we can make sure that that business follows the succession planning that you would like. If you have gas lease royalties, we can make sure that those royalties go to individuals that you want them to go to after you've passed away. And the planning that we do really focuses on during your life as well as after you pass away. So some of the things that the planning will also do is just make sure that you retain control, again, during your lifetime and after you pass away, that the beneficiaries that you intend to receive things do receive them in a timely manner, and for the purposes that you've intended. So, I recently had a family member who wanted to leave something to his daughter who has special needs, and he had all sorts of ideas about how he could do that other than a trust. And so it was a really eye-opener eye-opener for him to see that, you know, really a trust would be a way for him to control his estate beyond the grave. And so when Brittany talks a little bit about that today, you're going to learn a little bit more about that. And also the work that we do is going to give you clarity and peace of mind so that you know that your plans will be followed. So in today's presentation, we're going to talk about powers of attorneys and wills and trusts. I'm going to go through each of the powers of attorneys in full here. So the first power of attorney that we take a look at would be a financial power of attorney. And so if you go to the next slide, a power of attorney is really a written document that, that outlines what you would want if you were unable to communicate for yourself. So there are different types of powers of attorneys. There's a financial, healthcare, mental health, and living will. All right. And when we talk with our clients, we talk about the purpose of a power of attorney, and meeting with our offices, we want to make sure that you have good legal documents. And what a good legal document is one that outlines exactly what you want in all situations. And so when we take a look at the power of attorney, the reason that you would want to have that in advance of a crisis is if you got in a situation and you could not execute a power of attorney, your family may have to go to court for a guardianship. And so what a guardianship is it's a situation where you don't have the ability to sign a legal document to appoint a power of attorney. And so the courts would decide who would make those decisions for you financially and with your health care. And where that becomes problematic is a power of or a guardianship can cost thousands of dollars because you're dealing with the court system. And if you were in a situation where you were in a nursing home and you couldn't pay your bills, you likely could incur, you know, several thousands of dollars of nursing home costs while that process is being taken care of. So the simplest way is to really, you know, anytime anybody's over the age of 18, they need a power of attorney. So if you're over 18 and you don't have a power of attorney, you really should get one so that you can outline who can make decisions for you and what they can do. So with a financial power of attorney, what the document is going to do is it's going to outline specifically what your agent has the power to do. So you're going to see in powers of attorneys that the agent's going to have the ability to open and close bank accounts, sell real estate, defend you in litigation, make limited gifts, create a revocable trust for the benefit of the principal, which would be you. And most financial powers of attorneys do not allow your agent these powers to make unlimited gifts, create an irrevocable trust, create special needs trusts, or deal with digital assets. So at our office, when we're preparing a power of attorney and we're looking at your goals, and if you had a goal to protect assets down the road if you should need care, we always make sure that these specific powers are listed within your financial power of attorney so that your agent would be able to work with our office to follow the rules that would be in place at that time to make sure that assets are protected, they can set up trusts, and deal with any digital assets that you might have. All right, and another thing to keep in mind is that there was a significant power of attorney law change in Pennsylvania that went into full effect January 1st of 2015. And so what that did was really make powers of attorneys more uniform so that they all really kind of look the same. They might not have the same powers, but they all have the same execution requirements, that they were signed in front of a notary, 2 witnesses, and that there's a notice page on the front of the power of attorney. So if you do have a financial power of attorney and it was done prior to January 1st, 2015, it's a good idea to get that updated so that it is up to date with the law. All right, the next power of attorney we're going to talk about is a healthcare power of attorney. And the healthcare power of attorney works a little bit different than the financial power of attorney in that your agent that you appoint does not have the power to make medical decisions for you until you can no longer communicate your medical treatment decisions. So once the agent does have the power to make decisions, the document's going to allow them to consent to surgery, consent to admission or discharge from hospital or nursing homes. And it's the most important thing in a healthcare power of attorney is that it does have the HIPAA waiver in it. And that basically means that you're allowing your agent to get any and all medical information that they might need so that they can make informed decisions about your medical treatment decisions. So that would be within your healthcare document. So again, if you do have a healthcare power of attorney, make sure that it does have a HIPAA release in it. If it doesn't, then you're going to want to get that updated. All right, the third power of attorney is fairly new in Pennsylvania. It's a little over 5 years old, and it's called a mental health power of attorney. And that's a document that actually is not effective until 2 doctors have certified that you are incapacitated and can't make your own decisions. And so that's, you'll see in the slide there, it's called a springing power of attorney. It doesn't spring into effect until those 2 doctors have in writing said that you're unable to make decisions. And then what you would do is you appoint an agent to make mental health care decisions for you if you had Alzheimer's or dementia or any sort of mental health disorder and you needed admission to a psychiatric facility or you needed to enter into trial drug therapies, anything like that. And with this document, unlike the other 2 documents I talked about, there is an expiration date. So they do expire 2 years after you've signed them, unless you are incapacitated, and then they will continue with a doctor's letter. All right, and moving along to the final power of attorney, it's known as a living will. And at our office, we actually prepare a living will as a power of attorney first, living will instructions second. And the purpose for that is sometimes, you know, it's a gray situation where there might be disagreements between doctors on whether or not the living will should be implemented. We really want to put the power in the hands of your agent, the person who knows you best, so that they can decide when it should be implemented and get all the medical opinions before the document actually takes over. But what a living will is a written set of instructions on what you would want if you were in a terminal situation, no hope of recovery, and you can't communicate. And in that document, you would outline what you would want. Would you want pain relieving drugs? Would you want artificial hydration for ease of administering pain relieving drugs? Would you want life prolonging procedures? And so this is a very individualized document that we would go over with you, make sure you understood, and then you can get that implemented into your agents so that they would know what you would want if that situation should arise. All right, and then the next part about putting together a power of attorney is choosing who your agent will be. And so oftentimes people say to us, well, I don't want to offend any of my children. I should put my oldest child down. Really what you want to do is put the most skilled person for the job. And so that might not be your oldest child, that might be your youngest child, may not be your child at all, it might be a neighbor or a friend or a sibling. So really, when you're thinking about who you would list as your agent, you're going to think about who's good with dealing with healthcare or financial decisions. And the nice thing about separating those documents into financial, healthcare, mental health, and living will is that you can name different agents for all of those documents. You can have the same person or you can have different people depending on, what their abilities are. And when you name an agent, you can actually do it in a variety of ways. You can name somebody individually, you can name people jointly, or you can name as an or. So you might have 3 children and you want all 3 of them to act, but you don't want to burden them with having to be at the bank at the same time. So you could say any of them can serve individually or jointly. All right, so the most important thing to do about your powers of attorneys is, one is if you don't have them, you should get those, because again, anybody over the age of 18 needs powers of attorneys if they should become incapacitated legally. A spouse, a parent, a friend, nobody can make a decision for them without a written legal document. If you do have powers of attorneys, again, make sure that they have the language that we talked about for the healthcare, the HIPAA release, for the financial, that it was signed after January of 2015. And then make sure that your agents are still the people that you would want to make decisions for you. So over time, things change. Somebody might not be able to do that anymore. So you would want to review these often to still make sure that they're up to date and they name the people that you would want named. All right, so I'm going to turn it over to Brittany and she's going to talk about wills and trusts.
All right, thanks, Tammy. So all those documents that Tammy just went over, the financial, the healthcare power of attorney, all of those are really only good during your life. So they're effective if you become incapacitated, but you're still living. So what happens whenever you pass away is whoever you name under that document no longer has the power to serve for you. So they can't deal with your bank accounts, they can't deal with retirement accounts, they can't liquidate anything. So that's really where your last will and testament and any trust that you set up really become important documents. So a last will and testament is really just a set of instructions where you want your assets to go if something were to happen to you. And in that document, you appoint an executor or a personal representative, somebody that you trust, that, something happens to you, you trust them to make sure that all taxes are paid, that your beneficiaries get the assets that you designate, somebody that's responsible to really be able to handle all of that whenever you pass away. And I get asked a lot, do I really need a last will and testament? What if I just want everything to go to my spouse? Doesn't it just go to them anyway? And it's really important. I always recommend that you have a last will and testament, because if you don't, and something were to happen to you, what Pennsylvania does is they have a default designation of where your assets would go. So it doesn't always guarantee that it would 100% go to your spouse or the person that you would want it to go to. Whereas if you have a last will and testament, this guarantees that it would go to whoever you'd want to have that property. So it's a really important document to have, even if you do want everything to go to your spouse. And then if you do have minor children, it's good to list a testamentary guardian in the document. That is somebody who can step in for a temporary amount of time, usually 60 days, if something were to happen to you, and they can really take care of your minor children. They would act as the guardians until somebody could really file with the court to be permanently appointed as the guardian. So if you have minor children, this is a really important provision to guarantee that, custody would be turned over to who you would want to take care of your children if you weren't around to be able to take care of them. And then in Pennsylvania, a lot of people want to leave assets to minors. So if you have grandchildren, you would want to leave them to nieces and nephews, and they're under the age of 25, there's the option to appoint a custodian who can really manage those funds for them until they reach the age where they can manage them for themselves. So it's any age from 18 to 25. So if you don't feel comfortable with them having to be managed until 25, you could say at 21 they could get it outright, or 22, whatever age you would feel comfortable with. And then what would happen is the custodian would really manage the account until they would reach you designate, and then they could get it outright and use it for whatever they would want to use it at that point. Now, if you do have a last will and testament, it's really important to get it reviewed, because I always look to make sure that it was signed in front of 2 witnesses and a notary. This is really important because if you have an older will where it might not be notarized, maybe nobody witnessed it, what's going to happen is whenever you pass away, the court is going to force your executor to find individuals who can attest and sign a statement that that actually is your last will and testament, and that that's your signature on the document. So you can imagine, you know, if it's witnessed but not notarized, and your executor goes back to the old law firm trying to track down the original witnesses, they might have retired, they might have passed away. If you just have it signed by 2 witnesses and a notary. Because what that notarization really does is that tells the court, this is your signature and this is your last will and testament, and they don't require any additional proof at that point. It's called self-proving. So it just makes it easier for your executor. And then a lot of times if you want to leave assets to your spouse, that's a good thing to do, but I always like to call them the I love you but wills. So what if you leave everything to your spouse, but then your spouse is in a nursing home, or they're looking at applying for Medicaid benefits, or maybe already on Medicaid benefits, excuse me. You don't want your assets just going to your spouse and then they would have to spend it on their care. So what we put in our wills is we put in what's called a bypass clause. So all that means is you can leave everything to your spouse, but if your spouse is in a nursing home or on Medicaid benefits where they would have those asset requirements and limitations, it bypasses them and would go to your next in line, whether that's your children or grandchildren, whoever you would want to receive it. And what that planning really does is that helps to protect about 2/3 of your assets from having to be spent on your spouse's care. Now, I say 2/3 because in Pennsylvania, we have what's called the elective share, or the spousal election. And unfortunately, Medicaid is aware of this. So in Pennsylvania, you can never actually completely 100% disinherit your spouse. They're always going to be entitled to at least 1/3 of your estate. So what Medicaid does is they would force them to claim that elective share and take that 1/3. So additional planning would have to be done at that point to help protect that 1/3. But this bypass clause really helps to protect the majority of it, about 2/3, from having to go to the nursing home. And then there are certain assets that pass outside of your last will and testament. So this is really anything that has a beneficiary designation. So if you have life insurance, retirement accounts, IRAs, annuities, anything where you can specifically name a beneficiary on the policy, that is going to go directly to that beneficiary that you have named, regardless of what your last will and testament says. So if you have a life insurance policy and you have your ex-spouse listed as the primary beneficiary, but your will says that you want everything to go to your current spouse, that life insurance policy is going to go to that ex-spouse, regardless of what your will says. So it's really important to make sure that you know who the beneficiaries are on these policies, because a lot of times you get them several years ago, you forget who you have named, they kind of sit, you don't touch them, and you don't revisit who you named. So it's important to make sure that you know who the current beneficiary is, and if it's not who you would want, that you get it updated so it matches your current plan. The same with transfer on death accounts. We see these a lot with bank accounts or investment accounts. This is really an option where upon your death, it would automatically pay to whoever the beneficiary is that you have listed, the transfer on death beneficiary. So again, that would go outside of your will, so you can set that up directly with the bank or on the investment account. And then what it does is it just goes directly to that named beneficiary. And then if you own real estate jointly with siblings or other individuals, it's important to take a look at the deed that you have to the property, because there's several different options of how you can own real estate in Pennsylvania. And they might make a huge difference depending on what the deed says. So the first option is joint tenants with the right of survivorship. So say you own property jointly with your two siblings. On the deed, it says joint tenants with the right of survivorship. What this means is that whenever you pass away, your 1/3 of the property is going to go back to your siblings. It just goes automatically back to the other joint owners. So it really becomes a last to survive scenario. Whoever survives the longest ends up owning the property 100%. But then kind of on the flip side of that is if your deed doesn't have a designation, or if it says tenants in common, this is really the default if it's not specified. And what this means is that same situation, you and your two siblings own property, but it says tenants in common or it doesn't say anything, your 1/3 would then go according to your estate plan. So if you would leave everything in your will to your spouse, your 1/3 would go down to your spouse, then it would go to your children, wherever you and your spouse would designate for it to go. So this is really the option that we see the most whenever people own property jointly, because a lot of times it's family-owned property that they want to keep going down the generations. But it's important to double check just to make sure that it is set up how everybody wants that property distributed. And then the last option is really reserved for spouses. So if you and your spouse own property, this is really the default designation in Pennsylvania. So even if your deed doesn't say it, if you and your spouse own property, what this means is if you pass away, your percentage in the property goes 100% to your spouse, and that's just automatic. So that's called a tenants by the entireties. All right, so we touched on this, but it is important, like I said, to make sure that you know who you have listed as the beneficiary on all of your contracts, just to make sure you don't have an ex-spouse or maybe a parent who's passed away or a sibling that's passed away. Make sure that you have listed whoever you have in your last will and testament or who you'd want to receive that property. And the same with real estate. Make sure that you get a copy of your deed so that you know how you own that real estate. You can get a copy of it at the courthouse or, wherever, if your siblings would have a copy, just take a look at it to make sure that that's exactly how you guys would want that property to go. All right, so those documents that we talked about so far are really the basic estate planning documents. Those are really the foundation that we build every estate plan around. And they're really important, but they don't really provide comprehensive protection if you're looking to protect assets. So what we like to go is we like to go a little bit further and say, well, are you worried if you would become disabled or if you would need long-term care? Are you really looking to protect your assets if something were to happen to you and you'd have to go in the nursing home? So for asset protection, if you are looking to go into a nursing home and apply for Medicaid benefits, Medicaid is really the state agency that helps to pay for your care if you need skilled nursing home care. But because of that, they have very strict income and asset limitations of how much you can own and qualify for them to pay for your care. So what we look at is we look at transferring assets out of your name to help get them protected and help you qualify sooner for the Medicaid benefits. But what Medicaid does is they say, no, you can't transfer everything and then get us to pay for your care. So they have what's called a 5-year look back period. So for every $10,000, $10,732 that you transfer out of your name within that 5 years of applying for benefits, they will deny your application for 1 month. So this is something that we look at whenever we are looking to protect your assets. We want to make sure, are you healthy? Would you be able to survive the 5 years? Even if you don't get through the penalty, do you have other assets to help, pay through any penalty that there might be? So these are all things that we would look at. Each situation is a little bit different. But what we hear a lot as we go through that process is, well, I don't really need a trust. That's complicated. Can't I just transfer everything outright to my kids? It's out of my name, they own it, and it's a lot simpler than if we would have to do a trust. Well, I always caution people against that because of what I like to call the 4Ds. So for instance, say you're looking to protect your primary residence and get that out of your name. So we transfer that to your son. Well, maybe a year or two down the road, maybe your son gets a divorce. Now your house is in his name and it's subject to his divorce action. So you could potentially lose your home where you're currently living to your ex-in-law. Nobody wants that. So that's why we really don't recommend outright transfers because, you know, it opens it up to a whole slew of issues. Another issue would be debt. So say your son would get in a car accident. Now he has creditors looking for funds that they can recoup for expenses. Your house is now his asset, so they can recoup it for that as well. Or lastly, if he gets disabled, now he has to do something with the property. Or if he were to pass away, now your house is his asset again. So it goes according to his will or his estate plan. So he might say in his will, I really like my neighbor. I'm going to give everything to my neighbor. And you might not even know who that individual is, but because that's his asset, now it goes according to his plan. So in order to avoid that, what we always like to do is we like to set up a trust. And I know people tend to think that's a scary term. It's something that's really hard to manage. You have to set it up at a bank. And those are really all misconceptions. We like to make our trust very user-friendly. So what we do is I kind of like to liken it to whenever you purchase a vehicle. So you can really customize it on whatever your needs are. So if you have a lot going on and it has to have a lot of terms, that we have to include a lot of regulations, you might fit a lot into it like a minivan. So it might be a little bit more complicated than somebody else is planning. But if you really just have a straight plan where you want everything to be protected for your spouse, then go to your kids. You can manage everything during life. It might be streamlined like a sports car. It might be really simple to put together. So we take a look at all of that before we would recommend a trust and set that up for you, because it really is individualized on what your particular needs are. There's not a one type fits all for everybody. So how does a trust work? So a trust is really just a legal document. It's just a piece of paper. It doesn't have any sort of impact or legal protection until you would actually put assets into it. So the assets are really the gasoline of the vehicle. And you are really the one that decides what you put in there, how much you put in there. So some common things that we like to put into a trust is your house, because a lot of times that's really the biggest asset that you're looking at protecting. But if you have, you know, financial assets like bank accounts, investment accounts, life insurance, anything that's really just sitting and accumulating that you might not need access to right away, that's a good asset that we could put into a trust and help protect it from that 5-year look back and from whenever you apply for Medicaid benefits. The only drawback to that is we can't put IRAs or retirement accounts into a trust. And that's just because of the type of account they are, because they're tax deferred. So if we were to transfer that to a trust, that would trigger all of that income tax to be due. And a lot of times that's really not a feasible option. So that's a good asset that if you're taking those required distributions, that's something good to, you know, spend down, use on your finances or whatever you would need, because that's really an asset that we can't put into a trust and protect. The same with vehicles. Anything with a title in Pennsylvania, we can't put into a trust. So all of the vehicles would stay in your name. If you have campers, they would stay in your name, or a motorhome. Anything that has that registration would stay in your name alone. And then the last thing for trust is we would appoint what's called a trustee. That's really the driver, the one who manages everything that you would place into the trust. And what we like to do is we can actually name you as the individual who would be the trustee. So even if you would put your house in a trust, you would be the one that would still be managing that property. So if you would want to sell it 2 years down the road, downsize and buy a new property, you can do that. You don't have to get anyone's permission for that. You just sign all the documents like you own it right now. The same with an investment account. Say you have stock and you want to sell the stock or transfer it to a different company. You can do all of that as long as it stays within the trust, okay? But you don't have to get anyone's permission for that. The only thing that you can't do as trustee is really access the money in the trust. So you can move it around, but if you would need a distribution from the trust, what we do is we put in a back door. So we say, maybe your children, we appoint a third party. You would go to them and you would say, hey, I need $10,000 out of this trust, something came up. And then what that person would do is they would write the check and they would get the money out for you. So even though it's kind of locked away, it's not, because we still give you that third party access and through that back door where you would appoint individuals who could get it out for you. And the reason we have to do that is if we gave you direct access to the funds, it would lose that nursing home protection. So if the nursing home saw that you could write a check out of the trust for $100,000, they would say, great, get it all out and use it for your care. Whereas they can't force that third party to get it out for you. Okay. All right, so what are the main objectives for establishing a trust? So the biggest one really is long-term care that we just talked about. If you're really looking to protect the assets from nursing home care, creditors, anything like that, that's where we'd be looking at the long-term care protection. Now the first one, probate. So the good thing about a trust is because the asset isn't in your name alone, it doesn't have to go through the probate process. So that's really the process where your executor would go to the courthouse, put your will on file, and get formally appointed. In Pennsylvania, there are some fees associated with that, but it's usually no more than a couple $100s, and the process only takes about 10 to 15 minutes. So I don't really recommend that as the primary goal to set up a trust unless you have property that's out of state. That might have a little bit more of a difficult process. But it is one of the side benefits is anything owned by the trust avoids that whole process. And then a lot of people might have a beneficiary that might have spending issues, or that they might be worried that they might be getting a divorce down the line. So you can actually set up a trust to where whenever you pass away, the assets actually remain in the trust for your beneficiary. And then you can set the terms. So if you would want them to get 5% a year, $5,000 a month, whatever you would feel comfortable with, you can actually stretch that out and then appoint somebody to manage it whenever you pass away, and then they would follow whatever terms that you have outlined. And that really helps control it if you do have those concerns about a particular beneficiary. And then we're not so worried about the federal estate tax anymore. So that used to be about $600,000. If you had an estate around that range, you would be looking at a 40% federal estate tax. But that has actually been changed to $11.58 million. So if you and your spouse have over $22 million, that's something that you might want to contact us about, because there is some planning that we can do for that. But the good thing is with the limit, we're not really concerned with that as much right now, unless you're in that $11 million range. And then, like Tammy was talking about earlier, if you do have a beneficiary who is on Social Security benefits, receiving Medicaid benefits themselves, maybe they're disabled, it's important to do some planning for them, especially if you want to leave assets to them. Because anytime that they receive assets through your estate, that might hinder those public benefits that they're receiving, because there are really strict income and asset requirements for those. So one way to avoid that is you can actually have your estate pay to a supplemental needs trust. And this is a trust that really they can use for anything that their benefits don't cover, but yet it's not a countable asset to them. So they can still receive their Social Security or their Medicaid benefits, but if they would need clothing, or they would need to go on a vacation or travel expenses, somebody could dip into this trust and really use it to help supplement whatever benefits they're receiving. So that's a really good planning tool to keep in mind if you do have those beneficiaries. All right, and then some of the customization that we can do with our trust, there's several different types of trusts, and I'm going to go through what each of these mean. But they can be set up as a grantor or non-grantor. They can be revocable or irrevocable. They can be for special needs, or they can really be for that asset protection if you're looking at nursing home costs and long-term care costs. All right, so what is a grantor versus a non-grantor trust? So a grantor is really just the difference of who pays the taxes, the income taxes on the property that you put in the trust. So most of our trusts are set up as what's called a grantor trust. And what that means is, say you put an investment account in the name of the trust, it earns $1,000 in income. All of that income is going to be reported on your personal income tax return at the end of the year, just like you do now. So you don't have to file anything separate for the trust. It doesn't require a separate tax return. You don't have to get a tax number. It operates under your Social Security number, and you file it just like you do now with your personal tax returns. So that's why I say ours are pretty easy, user-friendly, because not a lot changes other than the title of the account or the title of your real estate. You still manage it, you still pay the taxes, all of that really stays the same. But on the flip side of that, in certain circumstances, we might look at setting it up as what's called a non-grantor trust. And really the primary benefit of this is any assets in the trust would avoid what's called Pennsylvania inheritance tax. And we're going to go over that a little bit more later, but if you have a beneficiary that might be looking at paying a higher inheritance tax, if you set up this type of trust and survive a year, it helps them to avoid that high tax. Now, there are some downsides to it during your life for the taxation. So one is that you would have to file a separate income tax return, and you have to get a separate tax ID number. So it really becomes like its own entity, just like if you owned a business and you had to file a separate tax return for the business. And it might hit higher income tax rates than your personal tax rate. So trusts hit about 37% for income taxes if you're about $12,900 in income. So we do this in limited circumstances, but we definitely want to talk about, you know, the pros and the cons before we'd set it up for your particular situation. All right, and then trusts can also be revocable or they can be irrevocable. So a revocable trust is one that you have full access to. So you can withdraw the funds at any point. You can revoke it, you can terminate it. And because of this, any trust that is revocable does not have any nursing home protection. So if you have full access to get all the money out of the trust, like I said earlier, the nursing home would say, great, get it out and use it for your care. So what revocable trusts are really used for, we used to see them a lot whenever the federal estate tax was a lot lower at that $600,000 range, because they really provided protection and planning for that tax. But now, if you're looking at nursing home protection, it doesn't have any nursing home protection. So we use irrevocable trusts, like I was talking about. So irrevocable just means that you don't have direct access to the funds. So once you put the assets in there, they are locked into the trust. But again, we put in that back door. So if you would need money that you would put away, you could go to that third party and get it out for you. Okay. And before we would set up any of these trusts, we do take a look at the taxes. So depending on the type of trust, they might have different tax concerns, and we want to make sure that we would give you the best tax advantage possible that's out there. So the first tax to consider is inheritance tax. Not a lot of people are familiar with this, but Pennsylvania is one of the few states that still has an inheritance tax when you pass away. And the tax rate depends on who the beneficiary is that's receiving the property. So if you leave everything to your spouse, the good news is that it's 0%. So your spouse doesn't have to worry about paying Pennsylvania inheritance tax. But if you leave everything to your children, what they do is they issue a 4.5% inheritance tax. And that's on whatever your assets are at the time that you pass away, whatever they're valued at as of the date of your death. So if you have a house that's worth $200,000, before that can go out to your beneficiaries, they're going to have to pay a 4.5% tax to the state because they're receiving that asset. So the non-grantor trust is what we look at. Again, if you're going to be leaving something to someone who's in a higher tax bracket, so say you're going to leave it to your siblings and they're going to be hit with a 12% tax, or maybe your neighbor or family friend and they're going to be hit with 15% tax. In that instance, it might be a little beneficial because they're going to have to pay that higher inheritance tax rate. Now, there are some assets that are not subject to inheritance tax. So the biggest is life insurance. So if you have a life insurance policy tax bracket, this is always a good asset to maybe look at leaving to them. So if you have a niece or a nephew and you want to make sure that they get something, maybe leave them a life insurance policy instead of a bank account or an other asset, because the life insurance, they won't have to pay that tax and they would end up getting more of your assets at that point. And then we also have to look at realty transfer tax. So anytime you transfer your house to a trust, they're always going to look at who the beneficiaries are that are listed in the document. So this is one of the things where Pennsylvania might not be current with the current times, but if you would list your stepchildren in the trust and you would say, I want my house to go to my stepkids, that would be fine. You wouldn't be charged that 2% transfer tax. But if you would list in there, if my stepkids passed away, I want it to go to my step grandkids, they don't take it down to the next level. So if you would have your step grandchildren listed as a beneficiary of that real estate, you would have to pay a 2% tax on whatever the current fair market value of your house is at the time that you record the deed to the trust. So we always take a look at this to help avoid this tax for you, because it could be pretty substantial if we would list a beneficiary that might not be under one of those exemptions. So the biggest that we see really is the step grandchildren. So there are ways to avoid that, and we would look at that if you would want to leave them something. All right, and then the federal estate tax, like I said earlier, unless you have over 11.58 million, you really don't have to be concerned with this tax. There is an option known as portability. So if your spouse doesn't use any of their lifetime $11 million, whenever they pass away, the other spouse can actually die with 22 million and still avoid the tax. So again, if you're concerned about this, we do have planning strategies for you to help avoid this 40% tax, but we don't see it too often now that the exemption is so high. But another tax to keep in mind is the federal gift tax. So each year, the IRS does allow you to gift up to $15,000 per person per year. And you don't have to file a gift tax return. You don't have to report it to the government. That goes tax-free. But to keep in mind, this is just an IRS rule. So if you were to apply for Medicaid and each year you gifted your beneficiaries $15,000, Medicaid is going to come back and they're still going to issue you a penalty for those transfers. So for Medicaid purposes, any transfer over $500 a month, and that's cumulative gifts. So if you gift to all your grandkids, all gifts have to be under $500 a month. Otherwise, they're going to start eating at that penalty, that $10,000 penalty. So keep that in mind when you do gifts. It might be good to get some advice from an attorney before you start doing that, especially if you're going to be concerned about applying for Medicaid or nursing home in the future. And we did talk about the income tax. So most of ours are the grantor trust, and that means that the income is going to be taxed at your lower income tax bracket. But if we do look at setting up that other trust where you'd have to file the tax return, again, it hits about 37% for about $12,000 in income. So again, there might be some drawbacks with that. All right, so for administration, which one's easier to administer? What are some of the concerns? So for a will versus a trust, both are going to potentially be subject to Pennsylvania inheritance tax. Really, the only way to avoid that is to set up that special trust that we talked about. But again, that's something we want to look at the pros and the cons before we would do that. For wills, you are going to have that fee to probate the estate. Again, it's usually a couple $100s. It's not real expensive. But trust, because they're not in your name alone, you do avoid that probate fee. So they don't have to file your trust at the courthouse. You don't have to pay that fee. That does help avoid that. Both are going to have attorney's fees involved to help your executor administer the estate. For wills, your executor is entitled to a compensation for their service. So this is set by law. So it starts at 5%, and it's a graduating scale based on how many assets you have at the time you pass away. But it is set, so they are automatically entitled to that, and they can take it if they serve as your executor. Now for trust, your trustee is also entitled to a fee for their service, but it isn't really as structured as an executor's commission. So for a trustee fee, it's really whatever would be reasonable compensation. So normally what we do is we would get a survey of what a bank in the area would charge, and we would do something in that area. Because if they would do a fee that's, excessive, say $10,000, and they only served an hour and they didn't really do anything, your beneficiaries can always challenge that and they can take them to court. So their fee always does have to be reasonable based on the hours, the knowledge, and the skill that they use in administering your trust. And then both documents, your beneficiaries can contest. So if you leave them $1, or if you leave them something that they're not happy with, or they feel that they're entitled to more, they are entitled to challenge that in court. Now, there is the option of putting in what's called an in terrorem clause. I don't usually recommend this because what this clause basically says is that if anybody challenges their distribution, then they don't get anything if they lose. Now, courts aren't too quick to uphold this because what they find is that if the beneficiary really has any probable cause to take the matter to court, they're going to allow them to do that and to pursue their challenge. So they're really not effective. So just be careful if you want to disinherit somebody or just leave them $1. I recommend just leaving them out completely. All right, so what happens if you haven't done any of this planning and a crisis occurs? Well, the important thing to take away is that even if you haven't done any pre-planning, you haven't set up the trust or protected any assets, even if you're in a crisis situation where you're already in a nursing home, if you have a spouse, a lot of times we can protect 100% of your assets. Okay, even if you haven't done any of this planning. If you're single, usually we can protect about half, maybe a little bit more. So, if you find yourself in that situation, it's always important to give us a call. We can talk to you about, the protection measures that are out there. But if you do pre-planning, a lot of times so it's important, to get that in place at least 5 years or before the crisis hits. That way you can help protect additional assets. All right, so what's the process? So when do you really need to think about, this planning and what planning for what stage of life? Well, if you're really a young adult, so you're just getting started in life, anyone over the age of 18 really needs to start out by having a power of attorney document and a last will and testament. So they might not have assets where they would need trusts and other planning, but it is important to at least have powers of attorneys, the advance directive, and the last will and testament in place. So the middle years, so where you might start collecting some assets, maybe you still have a mortgage or maybe you still have kids at home. Again, it's important to have those basic estate planning documents in place, but maybe you might want to start talking to a financial advisor about getting on track for retirement. Maybe you have a child with special needs, so you'd want to get some planning, for them, or maybe you have a house at this point that you want to protect. So it's good to kind of start the planning process early. And you can do it in phases as well as you go throughout life. Now, the pre-retirement years are really the important part to start getting all of this protection in place because, again, Medicaid does have that 5-year look back. So it's best to do the planning while you're in good health, while you know that you can make it the 5 years. So this is really important to take a look at anything that you don't need direct access to, life insurance, your house, to get those into a trust and get those protected. Talk to a financial advisor about, your retirement, make sure you're on track. If you have IRAs and you're concerned about planning for them whenever you pass away, talk to somebody about planning for your IRAs. This is really the crucial time to start the planning process. And then the post-retirement years, again, if you haven't had it in place, this is again a good time if you're in good health to start the planning, make sure everything's on track. But then you might start looking at additional protection because you might be getting closer to needing the long-term care, being more concerned about the 5-year look back. So it's good to have everything pretty much in place in the post-retirement years. So if you have that crisis occur, you're sure to be protected and everything's good to go. All right, so what to expect if you give us a call here at Steinbacher Good On Your Check. So we are a team. So like Tammy and I work together a lot. You're going to get an attorney that's involved. You're going to have a special Medicaid planner who's familiar with all of the Medicaid rules and filing Medicaid applications, and support staff. So it's really a team effort, and we try to make every plan individualized. That way, no matter what you need, what your concerns are, we can make sure that your documents really help to address that. And then you really do get quality documents. So I draft everybody's documents here as the attorney. So it's not a paralegal that's just filling in forms and drafting things. I really take a look at each estate plan to make sure that it meets all the tax requirements. It meets all of your, goals for distribution whenever you pass away. So I'm really the one that's taking a look at that and make sure that everything fits and is legal and good to go at this point. So how are we handling this during COVID-19, this new unprecedented times? So we are trying to move forward as much as possible with ICs, initial consultations, review appointments if you're already a client. So we do utilize Zoom a lot, the program that we're using right now. So we can schedule, if you want to see face-to-face, we can schedule a Zoom appointment. You can meet with me and Tammy, and we could go over your documents, your estate plan. If you're in a crisis, what that means, we could go over all of that with you. Or if you prefer maybe just a phone call, we do phone conferences as well right now. So we'd be happy to get that scheduled and talk to you over the phone and review any of your concerns. All right, and then for document signings, so we aren't doing document signings right now because our office is closed to the public, but we can make certain exceptions for that. So again, if somebody's in a crisis where they're already in a nursing home and that's a concern, we might be able to make an exception to get documents signed for them. Other than that, we're hoping to open up soon, but we don't know where we're at this point, but we'd be happy to get something on the calendar. That way you'd be ready to go whenever our doors are open and we're taking those signing appointments again. All right, so we do offer a free initial consultation. So if you're interested in anything that we talked about today, feel free to give us a call and we can get that scheduled.